much for joining us back in the room in time. It's amazing what a disciplined group can achieve. Now, as I promised in the morning, for the afternoon, we will switch to the other major topic for today, which is around dispute resolution. It's sort of a nice pair, I think, to have a substantive approach on contract law in the morning and then look at dispute resolution, because inevitably from contracts you at some point have some sort of dispute. And we have two main themes for the afternoon around dispute resolution. And the very first one is, I think, what we can call now the hot potato of the field, investor state dispute settlements. There is a lot going on within the UNCCA working group 3. This panel has been evolving as quickly and interestingly as the topic itself. So for those who saw several versions of the program before, you must have seen that the composition of this panel changed. We have, I'm going to introduce only the chair of the panel as all day long. So we have Daniel Forster, who has expertise in dispute resolution and investment in general, and he's from the Spark Commerce in Sydney. And he kindly accepted to chair this panel on a rather short notice, for which I am totally grateful.
And I'm very sorry to say I'm not Sarah Raymond. Hopefully I do her justice.
Absolutely. So we will, I think, based on this experience, we will have to call Daniel to be more active within UNCCA as well. And with that, I think I'm not going to steal more of your time and allow you to introduce the rest of the panel. Thank you.
Well, on that background, I am obviously very privileged to be here to welcome you all to today's third panel. We're going to delve straight into the working of UNCCA Trials Working Group 3 as it investigates the case for reform for investor-state dispute settlement. Now, as we've discussed, I'm pretty excited to see what this reform might look like, whether it will get off the ground, how it might be implemented, particularly in the context of what we can see as a shifting landscape in the realm of international investment transactions. Now today we have a very expertly led panel who have very keen inside information into how this working group is evolving, what their activities and what they're getting up to. Now I was going to offer a brief bit of contextual background to this working group, but before I do that I wanted to introduce our panellists. Firstly, we have Patricia Holmes here, who's the Assistant Secretary of the Department of Foreign Affairs and Trade. Now, I'm sure I won't do her CV enough justice, but I think it's important to appreciate that she was previously the Australian Ambassador to Argentina and has been awarded numerous degrees, and naturally has been influential in the ongoing discussion with reform in this area, particularly from the Australian perspective, and has acted as the head of the Australian delegation to the April 2018 session of Working Group 3. Today, Ms. Holmes will be talking about reform and what it might look like from the Australian perspective, and also give a bit of a key update on what the working group's been doing. We're also joined by Ivana here as well, who's a doctoral candidate at the Australian National University Centre for European Studies. She also holds the Australian Government Scholarship for her PhD research and is a sessional academic here at the University of Canberra. As a Croatian lawyer, as well as a career diplomat for the Government of Croatia, Ivana is going to be able to give us a different perspective, the European perspective, particularly in the context of the recent judgment out of the Court of Justice in the European Union, just so that we have a point of reference and a bit of comparison there. We also have Marina Kaufman, who is an associate at White & Case. Prior to that, she was very heavily involved in investor-state arbitration at Freshfields. She has also attended both sessions of the working group, so is very well placed to talk about a bit of an overview of the working group and also what reform might look like in practice. So with that said, a bit of a brief contextual background. I assume you're here because we all know what investor-state arbitration is and what it might look like. But let me start off by saying the days of sending warships to other states and trying to force reparations are perhaps long distant memory. At the same time, so too is this preconception that only Fortune 500 companies and large states are participants of investor-state arbitration. The ever-evolving globalisation of our international communities has welcomed the advance of instantaneous investment transactions and a more fluid and free-flowing investment market, opening the door to smaller enterprises and a need for a deeper understanding of this regime as a whole. The progression of this area of law is somewhat self-evident, not only by the participants here today, who are obviously keenly involved, but also the amazing increase in the number of registered arbitrations in this space. Now, while this progression might generally be viewed as a positive development, it's not without its issues. As the world becomes increasingly interconnected, there are signs of a little bit of a retreat from that global community. Domestic political regimes are increasingly aware of the impacts this area is having on their national citizens, and the strike of this balance between protecting the interests and participating in the transnational community is yet to be fully found. Now, these issues are central to the mandate of UNCCA's Working Group 3. On the back of a study into whether the United Nations, and I'll just call it the Mauritius Convention, I think we're all familiar with that, could provide a useful model for the possible reform, the UNCCA Secretariat highlighted some of the more pressing concerns with the regime, which we'll be talking about today. Now, some of these included a perceived inconsistency amongst the awards, a limited ability to review arbitral awards, a perceived lack of certainty, predictability and transparency in the regime, the ever-increasing cost, duration and complexity as lawyers become increasingly involved, the limited access to the regime and the ever-present issue of parallel claims, and the perceived independence and impartiality of arbitrators. Now, why are these issues of concern? Well, it'll come as no surprise to most of you that an inconsistent regime may lead to the fundamental erosion of the confidence that we place in this investor-state arbitration and a material limitation on its credibility. We continue to see increased tension between democratic states and the power of unelected arbitrators to lay judgment against what they may perceive as completely legitimate sovereign actions. We also have numerous examples of inconsistent awards, particularly concerning more complex issues such as the role of party autonomy in umbrella clauses, for example, or the application of the most favoured nation clauses, and the true reach of fork in the road provisions. The marked absence of any formal doctrine of precedent and the limited capacity into which we can review arbitral awards also makes it difficult to promote the reliability and predictability in investor-state arbitration. All the while, these factors are contributing to an increased time and cost to obtain an award in the first place, resulting in legitimate concerns as to whether, for example, low-income countries do have proper access to the regime. Now, of course, these issues have also travelled with increasing questions concerning the ability of existing treaties to evolve with the changing landscape of domestic regimes. Best evidence of this is the denunciation of the UNCCA Convention by Bolivia, Ecuador, Venezuela, as well as a more recent decision which we'll go through today. And so, Working Group 3 has been trusted with a very broad mandate to identify areas of possible reform. We heard this morning the three key areas that they're focusing on. The first is to identify these issues. The second is to consider whether reform is desirable to deal with them. And the third, if it is desirable, to come up with some suggestion as to what that reform might look like. Now, commensurate with its task, the working group has sought to adopt a unique and measured approach to the question of reform, seeking very cautious and gradual consideration of these issues. And indeed, it sought to distinguish itself from the Working Group 2, which is seen as a little bit more of a technical look into arbitration. With that said, and without further ado, I might hand over to Patricia to get us started.
Great, thanks very much, and thanks to Dharma for organising the event and for inviting me. I think I've been on this panel from the beginning, but I did actually instigate the shift in time, so I guess some of the transition I have to take responsibility for. So I have actually three hats, and for those of you who are familiar, it is a little bit of a joke about the hat business, which is always a constant theme in these discussions. But so I work on WTO law, FTA, oversee FTA legal work, and also the investment law, so in my branch in foreign affairs and trade. And I've been in this job about 3.5 years, so since returning from Argentina. And when I first started, the WTO was sort of the bulwark, you know, very settled, stable. Everything was, we've had panels and the appellate body, and, you know, sure, it had a few issues, but essentially it was looked at as the jewel in the crown of the WTO. FTAs, well, we were off busy negotiating them. That was all sort of full steam ahead. And the investment law was sort of the problem child. You know, I sort of came back from Argentina. We'd never had a case, and here we were facing tobacco and, you know, the costs and what a controversial case it was, our first case. And so we sort of had another look at the bilateral investment treaties and started noticing all these cases, and UNCTAD started doing it. None of you have looked at UNCTAD's website. They've done some fantastic research and work in this. I went along to the OECD Investment Committee that had a legal group, and the EU were there. We think we need a court. We think it should be more like the appellate body, the appeal, you know. And I was like, oh, that's interesting, and getting into that. And also at that point, we were going to have the US in the TPP, so we were going to have ISDS potentially with the US, and maybe an EU FTA with potentially ISDS. And like 3.5 years later, you know, my whole team has changed over. Every single person from the Prime Minister to my secretary, like, so I've obviously been in the job too long. And the issues have completely flipped about in terms of how their importance and the perceptions and the issues surrounding them. So it's just sort of fascinating, even over that period of time, to see how it's shifted. But I do think that is also kind of important background to some of this discussion, and Australia's involvement in it, and what drives us and what drives often countries. So countries can be very self-interested and very, not exactly short-term, but events that are happening in the short term can be very influential in their policy positions. And I think certainly that the tobacco case was relevant in that regard. We've also seen a couple of offensive cases from the Australian perspective, which we also hadn't seen much of in the past. So there's now three concluded cases. And of course, in the vein of we only have really important cases, we obviously have the Whiten case dispute that the Australian investors won against India, which was also quite influential in shifting the landscape on ISDS because of the reaction India took to the interpretation of MFN in that dispute. We've got another case that hasn't gone forward. It's even more fascinating on some of these issues, but I digress. And then I went along to an UNCCA kind of initiative, experts working group discussion in Geneva about 2 years ago, a year and a half ago, on ISDS reform. And really it was on the basis of the paper that Gabrielle Kaufman-Kohler and Michelle Protesta prepared, which has been quite important in pushing the process or framing the process in many respects of ISDS reform. And the EU were obviously a key driving force. I mean, there's no question that we're here in UNCCA talking about these issues because the EU pushed ahead quite quickly with their proposal on the investment court, right? But, and I mean, I'm happy to answer questions and go into detail on different aspects, but I'm assuming we're all sort of familiar with at least the notion that the EU have put out there, and I'm sure we'll put more from but that doesn't mean, I guess it's important to say from the outset, that doesn't mean that's going to be the outcome of this process. So it certainly was the driving force, really. But I think it's important to be clear that certainly the EU would see that as the outcome, but that's not necessarily the outcome, and it may look quite different to what the EU envisaged. The other point is there may be other kind of outcomes and other elements in this. So the EU ummed and ahed for a bit about whether they thought UNCCA Working Group 3 was the place to go, tried to do it themselves and decided that was all a bit too much hard work, really, trying to organise an international conference. And UNCCA were really keen. So Working Group 3, which had a vacancy, became the tool. And I guess it's also really interesting because I'm not that familiar with UNCCA and the Working Group 3 process. One of the concerns I think a lot of governments had was it would be too driven by practitioners, and perhaps a lot of you will go, well, that actually would be a good thing. But then for this sort of process, you really needed, there was a strong sense that you needed to have a government-led process, right? And I think that the transition from what we saw at UNCCA to that from that first expert group meeting to what I saw in New York, and a colleague in my team went to the Vienna meeting, is really this transition to a government-led process. And if we're going to get outcomes that are going to stick and be adopted by governments and accepted by governments, they're really going to have to be led by that process. And there really were only a handful of countries that had delegates in speaking roles who were not government officials from capital. So I think there's a high level of engagement and led by governments, and a lot of countries. I mean, we may have them all from others, but I think that is an important part of the legitimacy of the process, and I think that's something that is an interesting evolution. Not to say there's not a strong role for others. A lot of delegations include academics, include legal practitioners, and there's certainly a lot of capacity for the observers to make comments. And we've got a 3-day weekend here in Canberra, so you can all get the transcript and listen to the days of discussions if you are so inclined. It's all very transparent. So I think that's it's interesting context, and it definitely has moved ahead. Now, many could argue that one of the downsides of that is it's all a bit laborious and slow. Everybody feels they have to have their say, and they're making points that we've all heard X times before. And we're only going to have these 2 meetings for 1 week, in a year, so it's going to be hard to make progress. But actually, I think, having been to quite a number of different international meetings, I think this meeting went pretty well. I think a lot of countries had their say. The chair's doing a good job, was from Canada, managing the process. It's obviously not straightforward. I think there was a real sense, I think I gather you've heard about the 3 phases of the mandate. There's always a lot of focus. We have to stick with the phases. Everybody's focused, are we in phase 1, are we in phase 2? Right, so the big question is, everybody okay? We've finished phase 1, we're now moving to phase 2. Is that okay? Everybody done, And I think, we're sort of saying, let's not over-analyse this. We can still kind of go back and find new problems. But we're okay to move into phase 2, right? Because if you're too slow, the Europeans will they'll lose interest, won't they? Because they're really focused on their core. But I think Shane got it there. So don't hold me to it. But I think we certainly support the notion that we've done phase 1 and we're up to phase 2, which is whatever that is. Consider whether reforms are desirable, right? So we think about whether there's concerns, then we decide whether we think those we need to reform, given that, and then finally we get to what the reforms might actually look like. And I guess the other important thing to say, and this then moves a little bit to what Australia's view on all this is, we're not talking about the investment protections and rules, right, which is a little bit of a disconnect in some respects. So we do, there is reference, of course, to that, and there's obviously a bit of a blurred line, and occasionally some enthusiastic soul will suggest we should renegotiate, don't say the multilateral agreement on investment, but essentially we should try and consolidate the rules, right? So there is this notion that in an ideal world that would make sense, rather than having your 3,000 bits plus all your FTAs, right? But that's not what this process is going to do. I think there's a sense that really wouldn't be realistic. But nevertheless, that's an important backdrop. And so, I mean, in terms of, Australia certainly has recognised some of the concerns raised with investor-state dispute settlement. We include it on a case-by-case basis in our FTAs, and I'm sure we'll hear about the EU and what a fascinating case that's going to be. We're very excited for those of you who don't know that we got our mandate to negotiate our EU FTA on Tuesday at Brussels time, so we're all busy getting ready to kick off those negotiations. So we've certainly raised identified the concerns, and we share some of those issues, and we've certainly, if you look at what we did in the TPP text, looking at transparency and some of the more explicit safeguards. So I think that area of work is something that it's useful to refer back to, and it's important to recognise when you're saying, well, what's our view on all this, that is our view on a lot of the criticisms is reflected in our approach to negotiating more comprehensive text in those agreements. And I think a lot of countries obviously are doing the same thing, and it often gets raised that, well, the problem is some of the older agreements and the text, and how do you update that? But then if you're turning to some of the concerns, sort of stepping through some of the issues raised, so transparency, we've obviously got the Mauritius Convention, but nevertheless that gets raised, and then consistency and whether that's a desirable thing, how much of a problem is it? So there's obviously different views on that, I think a lot of this is how inconsistent, how much of a problem is it actually. Sometimes you'll hear, well, consistency is all very well, but you've got all these different provisions, so you would expect it. There's good consistency and bad consistency, so that was sort of a theme. So I think that there's a broad recognition that consistency generally is desirable. There have been clearly some disputes. Argentina sitting there with its examples of, very unhelpful inconsistency on the same agreement, divergent, polar opposite conclusions, right? That is bad, bad inconsistency. But then this question of, well, putting in a stringent appeal mechanism has its drawbacks as well, right, in terms of consistency. So quite a few different views there. Arbitrators, the idea of a code of conduct came up, and I think that actually, together with the court, is emerging as two potential areas of work for outcomes. Obviously, the code of conduct is seen as something that would be easier to get through. A lot of countries, pretty much everybody expressed support for that. Obviously, there's a few issues once you get into it, like the double hatting. But I think there's also a philosophical, just yell at me if I'm going on too long.
No. I wouldn't dare.
In a nice way. That's good. I think there's also a philosophical question about the arbitrators and the code of conduct. It's not just the double hatting, it's do we think that people who are currently the arbitrators, the lawyers, the counsel for the disputes, are they the right people to be doing this job? Or is it more the ideal person that the EU seem to have in mind for kind of a judge, a public international law person who doesn't grubby their hands in that arbitral world, right? So I think that philosophical question is something that will emerge as we go forward. And there was quite a debate about, well, we need expertise, but getting that balance right. So I think that that's quite an interesting debate, and I think there's still questions that also came up around newer issues around third-party funding, which I know at the ICA conference was an element that came up, and some of the NGOs that are quite involved. So we had a lot of after-hours events. It was like, do you go shopping or do you go to your NGO after-hour event, or your law firm after-hour event, or your lunchtime event? The people who provided lunch got good attendance. They left as well. So I went to quite a lot of those, I have to say, and I think it is really useful because you can delve into issues in a little more detail. So I think that they were kind of the core elements that were discussed, and everybody did feel the need to express views, and I do think that it was a reasonably sophisticated debate from a lot of countries that has clearly had experience. And I mean, frankly, a lot of countries have been sued a lot more than us, so they do bring that sort of bitter experience, if you like. So I think that in terms of going forward, I think that will be quite interesting in terms of the potential products, if you like, and outcomes, and we're guessing a little bit here. The only other thing I think I wanted to talk about or refer to is the link with other organisations, right? So there's OECD sitting there contributing. They've done quite a lot of good research work. Some of it's public, some of it's not. UNCCA I mentioned, but also ICSID and how all of it fits together with a new institution. So even if you think an appeal sounds like a good idea, and then you think, well, a standing appellate body or a standing roster of arbitrators, all these kind of options, and I mean, obviously you can have detailed technical discussions on how that might all work from the legal sense, but I do think if there's a will, you can work those things out legally. But what does ICSID think? And you've got the ICSID rules review going forward, and how's that going to connect? There's a bit of a competition between ICSID and the PCA about quite how they would, who's best placed to, if you like, be the home of any kind of future appeal structure. And then you look at what the EU's just pushing ahead with some of their FTAs, and they're identifying different bodies through that. So I think that will be quite an interesting element, and that cultural element of these organisations is quite important. So if you attach this to the PCA or the ICSID or, I don't know which other ones. I mean, the WTO is not really an option, but you could come up with others, and you've got to say, well, okay, we're kind of looking into the culture of those different organisations, and I think that's not an insignificant point. So I guess just to wrap up, there'll be July meetings of the Commission, but I don't expect to see a really big debate there, and then we'll have Vienna meetings. Korea was talking about having intersessional meetings as well, so there's a bit of work going on in that space. I think we'll hear more from the others on the different positions of different countries, but just to say, in addition, I've mentioned the EU. I mean, the US is really interesting because they obviously have been, very supportive of ISDS. That said, they've been at the forefront of many of the changes to the rules. So if you look at NAFTA and the joint interpretation and their approach to TPP, but given the sort of shifting sands in the US, they played a lower key role than they might normally have, so sort of leading it then to Japan and Russia and Chile to be sort of defending the status quo, or not the status quo so much as, but let's not throw the baby out with the bathwater. So a lot of that sort of debate, like reform codes of conduct, but not dismantle, and also will a court and appeal and all this be better? And in the context of some of the issues that we're seeing in the WTO, I guess it's become even more of a pointy statement. So
it's interesting that you mentioned that the discussion in the second group was quite fruitful and sophisticated. I mean, you're taking a system that's designed to take the politics out of disputes and give them a regime, and then what you've got is a government-led, very political, everyone wants their say kind of regime. It seems to be doing the trick.
Well, I mean, there's this argument that it's taking, but you can't take the politics out of a system when you're suing states under treaties that they negotiated, right? So I just don't think that's realistic. Maybe you're taking the gunboats out of it, but I don't think you can say you're taking the politics out of it. And certainly the argument that what led to changes to the rules is that isn't what people understood they were agreeing to, and I think there's pretty broad understanding of that. So there is a schism, and there is legitimate criticism that's going to have to be addressed. So this notion, the voice of, it's all fantastic and we can just leave it how it is, I think maybe one person is really pushing that barrow still at this meeting, and they were not getting a whole lot of support.
Okay, is really the relationship, the legal aspects of the European perspective. So the relationship between EU law and international investment law, which has quite shaped and is shaping the position of the EU, apart from all the different political aspects that are also obvious very much within the EU. So in particular, I want to discuss the judgment of the European Court of Justice in the case of ACMEA, in which the court, so that judgment came in March this year, in which the Court of Justice of the European Union basically said that the ISDS mechanism under the bilateral investment treaty between the Netherlands and Slovakia is incompatible with EU law. So while finally that judgment resolved the issue whether ISDS and EU law are compatible, there's now a whole new debate on what is the future of ISDS and what are the implications of these judgments for the EU bilateral investment treaties, ongoing arbitrations, as well as the EU agreements with third countries, one of which will be also the agreement with Australia. So I want to just explain a bit this judgment and what the court actually ruled in this judgment. So, and again, this judgment has to be understood in a broader context of what is the EU. And the EU is really an organization which is based on the rule of law. So the Court of Justice of the EU will always strongly defend that rule of law, be it in the case of monetary union or the independence of judiciary in Poland or the issue of asylum seekers. So in that context, we should also look at the judgment in the case of ACMEA. So in this case, the Court of Justice conclusively established that intra-EU BITs, so that are bilateral investment treaties between two member states of the European Union, have the adverse effect on the autonomy of EU law. So in general terms, what is this autonomy of EU law? Basically, the EU legal order stems from EU founding treaties, and it encompasses the core feature of this supranational legal order. So basically, the primacy of EU law over national laws, the direct effect, so that the EU law applies not only to states but also the citizens. Importantly, the obligation of consistent interpretation of EU law, so and also the full effectiveness of EU law in all member states. So international agreements also of the EU member states are also subject to the same requirements of primacy and effectiveness, because this is of course logical, given that the EU member states could not be permitted to basically diverge from internal market through an international treaty any more than they could through domestic legislation. So, and in this EU legal order, the Court of Justice and the member states' courts act as guardians of the autonomy. So, and this is crucial because in that system, the Court of Justice is the one that interprets EU law. So the central authority for the interpretation of EU law, and national courts ensure that consistency and uniformity in the interpretation through a preliminary ruling procedure. So which the court calls the keystone of the EU judicial system. And such procedural mechanism that exists at the level of domestic courts does not exist at the level of international tribunals. And that's important in the context of ISDS. So the Court of Justice established that the investment tribunals are not courts of member states, and actually that they have been created with that aim to be outside of the domestic legal systems, right? And at the same time, these investment tribunals are still required to apply national laws to the resolution of investment disputes. And EU law forms part of these domestic laws in every member state. And basically, because they are outside of that court system of the member states, they cannot act in the same way as national courts as guardians of the system. So they cannot refer questions of EU law or preliminary ruling to the European Court of Justice. And of course, it is important for the Court of Justice that there is such mechanism because it keeps member states in control in that sense. Interestingly, in the opinion of the Advocate General in ACMEA, in the same case, the Advocate General tried to resolve this issue by basically saying investment tribunals fulfill the case law criteria of the courts of the member states and they can be considered tribunals of member states. However, the court rejected that position, and one of the issue was also, even if that was the case, how could the Court of Justice actually ensure that these investment tribunals refer the questions of EU law to the court? So, but what is also important is that the judgment in ACMEA does not affect commercial arbitration. So basically the court said commercial arbitral tribunals are okay under EU law because private parties in commercial arbitration do not have the same obligations as the member states have under the founding treaty. So basically that's basically then having these investment tribunals or giving jurisdiction to investment tribunals is contrary to the EU treaties. And if member states do include such or have such provisions in their international agreements, that is contrary to the EU law. So given that the importance of that concept of autonomy of EU law, there is nothing really surprising or political about this judgment. Okay, so the judgment follows the line of reasoning of the court, which we have seen in previous opinions of the court. For example, where the court decided that the EU cannot join the European Convention on Human Rights because of the European Court of Human Rights, or that where the other opinion also where the court opposed the creation of a unified patent court in the framework of another convention. So basically, what does that mean now for investment arbitration? Well, the judgment is, of course, binding on all national courts of the EU member states, so not just on the referring court, which in this case was German court. And it is binding on all national institutions, which means that member states should basically now terminate their ISDS clauses in intra-EU bilateral investment treaties. Some of them have already done so, and if they don't do that, okay, Commission has another legal mechanisms under the founding treaties to actually force the member states to do so. And the Commission has indeed been a great opponent of this intra-EU BITs and intra-EU arbitrations, as it sees them as disturbing to the internal market. So, of course, it remains to be seen how will investment tribunals react to this, whether they will take the ACMEA into considerations. Before ACMEA, in all investment tribunals except one, clearly stated that EU law cannot trump international law. And they have basically held that there is no EU law, EU rule which would prevent member states from resolving their disputes but through arbitration, and that there is no rule which would actually forbid the arbitral tribunals to interpret, to apply EU law. So At the same time, they have also indicated that their intention is not to interpret EU law, but basically resolve the dispute, and that their interpretation is not binding on the member states. So, and in that sense, the EU law has been taken mostly as a question, matter of fact, in these arbitrations. And the arbitrary tribunals have also attempted to harmoniously interpret member states' obligations under international agreements, so harmoniously with their obligations under EU law. What is also important in the context of this decision is a number of these intra-EU arbitrations actually do not concern issues of EU law at all. Most of them are basically within the policy areas which are in the competence of the EU member states. So if you look at the very famous example of the case Vattenfall 2 against Germany, so Swedish company Vattenfall challenged under the Energy Charter Treaty Germany's decision to phase out nuclear energy. Okay, so that decision by Germany was not mandated by EU law. That was fully exercise of Germany's domestic policy. So it was in reaction to 2011 Fukushima nuclear incident in Japan. So basically, following UNCCA, this kind of international issues cannot go to international arbitration anymore. They should be resolved under the EU law, well, domestic law and EU law. So definitely the UNCCA judgment is the beginning of the end of these intra-EU VITs and intra-EU arbitrations. But there are sunset clauses, so even if member states denounce their bilateral investment treaties, investors can continue to sue member states. Well, in such cases, the participation of EU member states in arbitrations would be contrary to their obligations under EU law. So that's important to bear in mind. And all member states taking part in such arbitrations would actually have to lodge a jurisdictional objection and withdraw from such proceedings. And of course, should international investment tribunals continue to uphold their jurisdiction in these arbitrations, then the member states will find themselves in the situation where their compliance with EU law basically leads to non-compliance with their international law obligations. Most commentators and the European Commission agree that UNCCA applies only to intra-EU aspects of investment arbitration. However, there are many commentators that also question what does this mean for extra-EU VITs, so the VITs that EU member states have with third non-EU states. And in particular, what if such VIT expressly stated that a tribunal should, among other issues, decide the case on the basis of domestic law? So if EU law again forms part of the national law of member states, and potential conflicts with EU law cannot be avoided. So would the Court of Justice in that kind of situation also rule that there is the jurisdiction of investment tribunals should be excluded? Of course, such approach would lead to asymmetrical outcomes. So basically, in this scenario, within the EU legal order, EU law should apply, and the investors should go to domestic courts, and in third states, EU investors could use actually bilateral investment treaties and investment tribunals. So basically, that would, of course, have significant political consequences, but also legal consequences, because the protections that investors have under EU law and international law, international investment law are not quite the same. So it would probably be wise for investors not to choose the seat of arbitration in the EU to avoid that possibility of even having the Court of Justice decide if that question comes to it. So definitely ACMEA means the end of ISDS for the EU, and the EU has already announced that in agreements with other countries, with Canada, Vietnam, well, Japan, they still haven't agreed on the dispute settlement mechanism in that agreement. In Singapore, so following that, actually now commentators are not sure whether that proposed investment court system would be consistent with EU law, because the level of abstraction in that judgment is really high. So basically, the question is, does CETA has enough provisions on investment court system which insulate that autonomy of EU legal order? So on one hand, that court system would not be competent to apply domestic or EU law. It would not have jurisdiction to rule on legality of any measure under EU law. It would have to consider EU law as a matter of fact and follow the prevailing interpretation. And any meaning that they would give that such tribunal or under that investment court system would actually give to EU law would not be binding in EU courts. However, also the purpose of that system is again to allow foreign investors to challenge national acts, and again these acts could involve questions of EU law again or EU acts, and also they might have to interpret and apply EU law both directly or indirectly. So basically, especially if they're faced with questions where there is no prevailing interpretation of EU law. So after all, again, this tribunal would be outside of the domestic law systems, which was exactly identified as a problem in ACMEA. So the European Court of Justice will will provide opinion on this matter, hopefully sometime next year. So we will actually see whether the proposed investment court system is compatible with EU law, and if it's not, it's going to be a huge, actually, political problem for the EU. So, of course, last but not least, the international investment community's reception of that proclamation of that of ISDS in the EU will really be a test for the EU's global power. And I would say in practical, legal, and political terms that basically this judgment in ACMEA has disclosed more questions than it has really resolved. So, thank you.
So with time in mind, I was going to open up for a bit of a question and answer session now, but I wanted to, Marina, if you might lead us off with a bit of an overview. I know you were at both sessions, but also we've got ideas throwing around about what the issues are, what might reform look like, and how is this going to be implemented in practice?
Sure. Well, I think we really need to understand the root problem here in order to understand some of the complexity in dealing with this work. So, as we may or may not know in this room, the system of investor-state arbitration was modelled on commercial arbitration. So when you look at the ICSID Convention, it establishes a mechanism. It doesn't deal with substantive standards. And at the time that the ICSID Convention was negotiated, there were no bilateral investment treaties. So it wasn't negotiated with the current system in mind. It was negotiated to facilitate the resolution of disputes involving investment contracts between states and investors. So right now, the entire FDI and international investment system has developed in a way that was not really foreseen at the time that the convention was drafted. And so I guess you could say that investor-state arbitration is going through its terrible teens. So right now, the problem is is this system fit for purpose? Because when you think back to when the ICSID Convention was negotiated, they didn't really have in mind that a lot of these issues of public law would be before tribunals that were unelected, appointed by investors, and the systemic issues that have now developed were not foreseen. So right now, the core issue is a legitimacy crisis. So is it legitimate to have unelected arbitrators who may or may not have public policy and government experience decide on disputes that have a really significant fiscal impact and a really significant political impact domestically on states? So this is, you can see that this is the focus of UNCCA's work, because UNCCA is trying to address whether this system is legitimate and whether coming into this legitimacy issue is the cost issue. Should states be up for such massive awards, and this process having become so complex, it's very, very costly. And the fundamental issue that we're dealing with is systemic, is system design, because unlike the WTO, the investor-state system has now become a system of many thousands of bilateral investment treaties. So it's very, very difficult to reform. And what I would say on that point is, when you think about the legitimacy of decisions and whether decisions are consistent or not, and there is no appeal mechanism, then many states are saying, well, how can you possibly resolve this without any merits review, such as what we have in our domestic systems? But then again, when you look at the design of the system, if you look at proposals such as a court or such as adding an appeals mechanism somewhere, you really have to think, is that going to address the fundamental issue of inconsistency in decisions and how much it costs to resolve these disputes, because you have to have lawyers making multiple arguments on multiple inconsistent decisions, multiple lines of authority? You really have to think about, well, what is the solution given the structure that we're dealing in? So if, for example, a court is chosen, how is it that a court will be effective unless it's completely multilateral? So if you have a court that deals with, for example, the EU has negotiated for the court system in, correct me if I'm wrong, but I think it's 4 treaties now. Okay, so that's fantastic. There'll be a court system, there'll be a review mechanism, but how will that impact on the universe of treaties? So if everyone doesn't sign up to the court, and it's not multilateral, then you are not actually dealing with the consistency issue. Similarly with an appeals mechanism. So states are free to draft an appeals mechanism into new treaties, or they can use the Mauritius Convention as a model, design the appeals mechanism, consider issues of institutional design, and then states can sign up to it so that it applies to all of their treaties, and that would be an efficient way to do it. But what if some states don't go for the option in the end? What if they disagree with some aspects of its design? What if you're a state that likes arbitration, and there are a few in the room who say, in our experience, arbitration works for us, and we've addressed certain aspects that don't work bilaterally in our treaties. So what will ultimately be the result? Well, I'm not going to do any crystal ball gazing here, but ultimately, if you start with a system which is fragmented in the first instance, then unless you have a completely multilateral solution and buy-in from most states, then to me it seems that you're going to have the potential over a transition period and perhaps beyond for greater pluralism in the settlement of investment disputes. And I really take no credit for this observation, because this is an observation that's been put far more eloquently by Anthea Roberts, who was supposed to be on this panel today. But I quite agree, and I think that she's absolutely right. And so in this reform process at UNCCA, another thing that has to be borne in mind is this is one track and one international organisation that is doing work in this area. But parallel to UNCCA's efforts are bilateral reforms that are being undertaken by states. And it's a slow process, but basically you have case law that says there's something deficient in this area, you don't like it, you've got to draft it in, and then you've got to negotiate with your counterparties to very slowly resolve these issues, and states are doing that. There are also institutions like ICSID and like the Permanent Court of Arbitration and others like the International Bar Association that are dealing with different aspects of the legitimacy crisis. So, for example, the PCA has developed a list system for the appointment of arbitrators, which is working very well, which takes some of the politics out of the party appointment system, because you start with a list and each side strikes off the list. So it's you're left with arbitrators that you can both live with, as opposed to, well, we want to nominate this person and then we're going to fight about it because we're going to have challenges to that person. So other organisations such as the IBA have created soft law instruments on ethical concerns, for example, disclosure by arbitrators to avoid conflict of interest. And so there's a lot of parallel work going on. But as a practitioner, I can say that practitioners don't really have a role at this stage of the UNCCA process, because we're not currently dealing with technical work. We're dealing with a completely political process of identifying the issue, and the issue that's been identified by and large is fitness for purpose, now that we have decades worth of case law. But practitioners shouldn't be worried that investment arbitration or the resolution of investment disputes, whether by arbitration or in a court or in a two-tiered system, is going to deprive them of work, because whatever happens, if, for example, there is a new mechanism, well, of course, there will be arguments about how does that work, and dealing with new language and dealing with a transition to a completely new and unknown system. So there'll be lots of work to do for practitioners, and practitioners will just be on the receiving end of whatever the political process delivers.
Congressman and coffee time, is there anyone from Big Law who wants to challenge that? No, but seriously, any questions or comments? A little bit to take in.
I just have one question for Patricia, actually. Normally in the UNCCA process, there's an endpoint at some stages discussed. What sort of text is going to come out of the process? Is there any thought as to, at the end of the day, where these things might lead, or where the discussion might lead?
Yeah, so I mean we're in phase. We're going to go to phase 2, and I think there's a sense that you can't get ahead of yourself when governments are leading this. So and then it goes to phase 3. Reform desirable, develop relevant solutions. I mean, it will take time, but I do think that there is progress being made. Now, what those outcomes will look like, I mean, I mentioned too, a code of conduct and that arbitrator element. I think that could link in with some of the ICSID rules, because that process is going forward. We're expecting some papers from them kind of middle of the year, and then a conference in September. And obviously the EU are very focused on having a mandate and starting negotiation for a court. And so I think that the politics in the EU, I mean, who knows, but unless things change, I mean, they have a clear mandate now and I think they will pursue that. Now, whether not everyone's going to come on board with that, there's no question. I mean, I don't think the US, no matter what their political stripe, is really going to come on with the Court, and other countries will as well. But I think that the EU is really pushing this quite heavily in, and you've seen it in their FTA. So I don't think it's out of the question you'd have some sort of plurilateral mechanism stuck somewhere, developed in some way. I mean, I think no outcome is relatively unlikely. And I should caveat all this by saying, you know, Australia hasn't taken a formal position on the court. We're open to discuss reforms. We're certainly engaged in this process, but we haven't sort of supported or not the court process. I mean, I would say just a couple of other comments on the presentations. There's not many voices in the room that are, so we've seen, you know, Brazil, South Africa, a few countries saying let's just rely on state to state, but I wouldn't say that was an overarching theme. I think most countries, and you know, New Zealand's seen a bit of reform in their position, but most countries are still, and maybe the US, there's still a mechanism there. And I do think practitioners, like, we are interested to hear what your perceptions. So even though I agree it's a very political discussion at the moment, like it is interesting and useful for us to hear perceptions from the practitioners. And you know, we heard from a few of the lawyers who work for states largely. And if I may very quickly, on ACMEA, I mean, we have seen some decisions on this. So the Airbus withdrew their case in a Dutch-Polish bit, citing ACMEA, saying, well, we can't pursue it. But Spain was lost a case when it was decided that this didn't apply to the European Energy Charter, which was quite interesting because that's a multilateral treaty. So that was the arbitrators, if you want it. But the Commission's view is clearly that this doesn't affect extra EU bits, if you like. So I think that that's quite interesting to see where that goes.
Any other comments, questions?
Just a general question about, I've been hearing investor-state dispute settlement, but mostly it's investor-state arbitration. Is there any conversation in the working group about using other dispute settlement processes? Clearly, arbitration is going through the teen crisis years. So is there any conversation about doing use of other alternative methods?
Like mediation or
conciliation, mediation, MEDAR, or whatever it is that might work.
I mean, I think that feeds into the discussion on investment facilitation and avoiding disputes and this sort of thing. But this is really focused on once you get to the point of arbitration. So, I mean, there is that discussion, but not in this group. So I don't know.
I can add something coming out of the ICCA Congress, the International Council for Commercial Arbitration Congress, in terms of some of the issues that states face with mediating or otherwise settling these types of disputes. So there was a panel dealing with what are some of the challenges of representing states in these types of matters. And there was a woman from, I can't remember which ministry, but she was from the Czech Republic, and she said openly, and this was in the context of this sort of discussion, I would rather lose a case than settle it. Why? Because in many countries, the officials that are in charge of these cases, they are fearing personally for not only their professional career, but sometimes even for their safety, because some regimes are not like Australia, and then they'll be audited and they'll be forced to account to government about why did they choose a certain arbitrator, why did they take this strategic decision, and of course settling your matter is the largest decision that you can take at all. So she made that comment, and I think that that doesn't apply to every country, but certainly in many countries that that is a concern of the people that are personally in charge of making decisions on those types of matters. So just to add that.
Well, with that said, would you please join me in thanking our experts?